Well, hi everyone. Time for another update on Rhode Island's Washington Bridge fiasco. It just gets crazier all the time. So last Friday, August 16th, the state of Rhode Island filed lawsuits against several engineering firms and contractors who have previously been involved with work on the Washington Bridge prior to its emergency closure in December 2023. So for this video, I'm going to give an overview of the details associated with this lawsuit, and I'm also going to indicate how I think these engineering companies may choose to defend themselves. I'm not a lawyer. This in no way is legal advice. I'm looking at this from a professional engineering services standpoint. I own my own engineering company. I've worked with engineering companies over decades. And so in the course of engineering business, there's some key concepts to limit your liability. The first is client selection. And I think a lot of people aren't going to work with a client who is lawsuit happy or demands excessive liability indemnification or excessive levels of insurance. So to recap, on December 11th, 2023, a young engineer, as Peter Alviti, director of Rhode Island DOT, said, who was involved with the repair work for the second round of rehabilitation of this bridge. The previous episode of rehabilitation was in the late 90s. This was the second go around, and I believe this engineer was associated with a VHB, an engineering consultant, and he discovered these broken anchor rods. They've never released the name of this individual. It's probably for the best. I've got a project I'm involved in right now. It's a design build toll road project. And I was talking to one of the superintendents, and he was telling me how whenever they have to do a lane closure, people are just screaming at him out of the window. They're screaming at flaggers. Any construction worker that can catch the motorist's eye, they're getting flipped off and yelled at. And it's like, do they honestly think these people had anything to do with the lane closure? They're just doing their job. So here's the photo of the broken anchor rod that was discovered on December 8th. 2023 and led to the December 11th closure of the westbound bridge for Washington Bridge. So back in June, the state of Rhode Island, at the behest of the governor, engaged a law firm, actually two law firms, to see if there was anybody they could sue relative to the lead up for having to close this bridge on an emergency basis. So everyone who got a letter was named in the lawsuit, and there was an additional two firms that were named in this lawsuit. So we have AECom Technical Services, Aetna Bridge Company, Aries Support Services, Barletta Heavy Division, Barletta Aetna, I-195 Washington Bridge North Phase 2 Joint Venture, Collins Engineers, Commonwealth Engineers, Jacobs Engineering, Michael Baker Incorporated, and later on they're referred to as MBI in this filing, Prime AE Group, Steer Engineering, Trans Systems, Vinay's Hangen Bruslin, that's the VHB. So interestingly, Aetna, named in this lawsuit, is currently awarded the contract to do the demolition of the Washington Bridge. So we need to go over some background information to put things into context, the chronology of what's been done. And so starting in the 60s, the state of Rhode Island hired Charles A. McGuire and Associates, known as McGuire and Associates, to design the Washington Bridge. They completed the original design of this bridge in January of 1967, and the bridge was open to traffic in 1968. They note here, the Washington Bridge has an extremely unusual design and may be the only bridge of its kind in the United States, if not the world. And I can tell you, as I'll show examples of, that's not a good thing. The complex structure is composed of 18 spans of various structural types, including post-tension cantilevered beams. And we compiled this table. Shows you all the firms and their involvement. You have people involved in a design capacity, construction capacity, and then several engineering firms that just performed inspections of this bridge over the years. So after the emergency closure in December 2023, the state of Rhode Island, the Rhode Island DOT, engaged with this engineering consultant, VN, to do an extensive forensic analysis of the Washington Bridge. It involved inspections, non-destructive testing, destructive testing. It was a very comprehensive investigation, according to their report, and this type of investigation would be well beyond what would be expected as part of routine inspections, in my opinion. But in this VN report, they go over the key problems with this bridge, failure of multiple tie-down rods. There's corrosion, missing grout around the post-tension anchors. Just a lot of problems with this bridge. Continuing on with this filing, they referenced the Liechtenstein report. So this was an engineering study done in the 1990s, and they were focusing on issues with corrosion and cracking around these post-tension concrete elements. In this filing, they indicate the Liechtenstein report expressed an additional concern with the state of the post-tension cantilevered beams. Ultimately, however, their calculations indicate that the diagonal cracks which follow the tendon profile in all likelihood were formed during initial tensioning of the tendons. They predicted that it was unlikely that the cracks in the post-tension cantilevered beams would continue to grow. As future inspections later revealed, however, that prediction was wrong. So those reports led to the first rehabilitation work done by 1998. And then Michael Baker Incorporated apparently was brought in 2011 to do an inspection to see how that rehabilitation had held up over the years. And as a result of their inspection, they found that the bridge was in poor condition. And they're referencing specifically the superstructure because I don't think they were in a position to inspect the foundations. In fact, I know they weren't. So as a result of Michael Baker Incorporated's involvement, this led to bringing on additional consultants to prepare a package, a design package and plans for a second phase of rehabilitation for this bridge. It says the consultant shall make recommendations based on his field observation and test results as to the type of repairs necessary to completely rehabilitate the existing structure. So AECOM was brought in for that work. And I'm going to digress here slightly. It's still related here, but another way to limit your liability potentially when you're providing professional engineering services is how you craft your marketing material, even your proposals, language on your website. You never want to say we're the best or we're expert, because that can lead to increased expectations about the level of service and the quality of service that's being provided. And in this lawsuit, they referenced that at the time, AECOM was the #1 ranked pure design firm by Engineering News Record and was also ranked #1 in transportation. Well, the ENR rankings are based on revenue. They're not using a team of judges and doing a technical evaluation of who does better work versus somebody else. That's not part of it, but that's sort of the implication here, right? Because in this lawsuit filing, the lawyers are trying to get their narrative out there to the public so that later that translates to a narrative absorbed by a potential jury pool. They go on to mention AECOM's letter of interest. Technical proposal includes a background section on the Washington Bridge that explains the design of the bridge, previous repairs to the bridge, and previous inspections. As a result, AECOM knew or should have known of the bridge's unusual, perhaps unique design. Well, maybe that's fair or maybe it's not. I'm going to get into that here. You know, I'm coming at this again from a perspective of an engineering consultant. There may be merit to some of these charges. I don't know. I'm not privy to all the information. But what I want to point out as I'll go through this, there's a revelation really about the mindset of Rhode Island DOT and the government of Rhode Island. And they're really, I think, doing themselves a disservice by the way they're going after these multiple firms, engineering consultants and contractors, in a batch fashion. And I'll explain why here in a second. So AECOM transmits their reports and final construction plans to Rhode Island DOT. They point out here in the filing, the 2016 construction plans failed to identify, analyze, or recommend improvements necessary to completely rehabilitate the existing structure, as required by the 2014 AECOM contract. Well, when you use words like completely, that's problematic or can be problematic. So as a result of that, Rhode Island DOT entered into a contract with Carty Corporation for this rehabilitation work, but ultimately that contract was canceled. As a result of Carty Corporation's work adhering to the traffic management requirements for which AECOM was responsible, unacceptable levels of traffic congestion and delays resulted. Consequently, the contract was terminated. So it looks like they're still blaming AECOM for that. And by the way, I'm going to mention there's a lot of great local reporting going on for this story. It's such a rich story in terms of all the characters, all the plot lines, as it were. And you know, Golocal is one of them. There's been many other local media sources that are staying on this story. I just want to bring an engineering perspective, or the business of engineering perspective here, because I think the way Rhode Island DOT has conducted themselves from the beginning of this closure back in 2023 has been problematic at best, and I'll give you reasons why I'm saying that. So then this filing mentions all the other people who were involved with inspection of the bridge throughout the years. And then Rhode Island DOT goes out with the second rehabilitation package. This was in 2021. The 2021 RFP further stated, among other things, the design build entity shall perform concrete repairs and crack sealing for the existing structure that is to remain and be reused, including but not limited to drop-in beams, precast beams, cantilevers, substructures, spandrel walls, and all other concrete items. Their proposal allegedly emphasized that if they were awarded the work, the result would be a rehabilitated bridge with a 25-year life expectancy. So this was about a $64 million contract. It was supposed to be done by 2025, 2026. So this was the work that they were doing that enabled them to discover the problem with the broken tie rods that previously had not been discovered. And I think there could be some legitimate reasons why those broken anchor rods were not previously observed, but again, I'm going to cover that here in a second. So VHB was on this team for the rehabilitation project, and they mentioned in October of 2023, so a couple of months before they discovered the broken anchor rod, the joint venture issued rehabilitation plans stamped by VHB, Barletta, and Aetna. These plans still did not address the existence of any possible problems relating to the tie-down rods at Piers 6 and 7, and did not call for repairs to the post-tensioning system. And then they talk about the emergency closure, which I've already covered. Now, as I mentioned, this lawsuit filing was 44 pages long. I'm going to focus on AECOM because they're named in all the potential range of liability in this filing. There's other companies that have some of these elements, but AECOM had all of them. So I'm not going to go through those other ones. I'm just going to focus on AECOM just for illustration purposes. So the first count here, breach of contract. And again, you have to be really careful in terms of the language in any contract that you execute with your client. And then they allege negligence. AECOM, Steer, Prime, and Area Support Services owed the state a duty to conform to the standard of skill, care, and diligence exercised by the average professional engineering, consulting, construction, inspection, and design firm. So that's a key thing there. So for professional service providers, the finding as to whether or not you're negligent boils down to whether or not you followed the standard of care. And I'm going to provide a definition for what standard of care means. Then you have breach of contract. I have no idea what's in this contract. And then you have contractual indemnity. And this is usually a sticky one in the agreements I review. You, as a professional service provider, you want to limit your liability to what's covered by your professional liability insurance, aside from commercial liability, for vehicles and things like that. We're focused on professional liability here. And according to this filing, AECOM agreed to defend, indemnify, and hold harmless the state for all damages, losses, or expenses arising out of any of its acts or omissions without regard for whether such damage, losses, or expenses were foreseeable. Again, if that was the language in there, normally you want to exclude defense costs because most professional liability companies won't cover defense costs. And you want to limit your liability to the extent of your negligent acts or omissions, but it has to be tied to negligence. And I've seen some agreements where they expect the professional to indemnify the client against the client's own negligence, which is a non-starter, but you see that in agreements all the time. And then breach of fiduciary duty, essentially the state saying that AECOM held itself out to the state as a trusted expert in professional engineering, consulting, construction, and design. You'll notice a theme here. They're focused on private sector entities. There has been no mention by the governor's office in Rhode Island or the Rhode Island DOT of looking at Rhode Island's fault in all this. I mean, they're making it sound like they were taken advantage of, sold aluminum siding when they didn't need it, and they know nothing about aluminum siding, but that's what happened. Essentially the narrative, if you really look at it, is, hey, we're the state, we have a DOT, but we know nothing about bridges, we know nothing about inspections, we know nothing about design. We're 100% reliant on whatever our consultant tells us and whatever the contractor does. And I'm not buying that. And that'll factor in later on if there are any damages awarded. I believe this is going to be a contributory negligence situation. So let's say someone's found to be at fault for $20 million, but they were only 50% at fault. So they would only be liable for $10 million in that scenario. And I think in all likelihood, the state of Rhode Island is going to end up, if they get a competent jury here, with a significant portion of the liability in this whole situation. But again, that's speculation on my part. So let's look at a definition of standard of care. Standard of care, the firm shall perform the work in a manner consistent with that level of care and skill ordinarily exercised by members of the profession currently practicing under similar conditions in the same locale. And it goes on to say the firm makes no warranties or guarantees, express or implied, relating to the firm's services, and the firm disclaims any implied warranties or warranties imposed by law, including warranties of merchantability and fitness for a particular purpose. So that's the kind of language you want to have in your agreements. And that's another interesting point. If you have a handful of professional engineering service providers that are doing inspections of this bridge, and none of them uncovered these broken rods, I mean, I believe it's quite possible these rods weren't readily accessible. There's been other reports that, for example, expansion joints couldn't be inspected because they were chock full of pigeon dung. So, you know, there's aspects to this in terms of, in the contract, what was stipulated for access to perform these inspections? What was Rhode Island DOT expecting? What were they willing to pay for? That could be a factor here, that there might have been constraints in terms of how people conducted their services. I don't know that. I suspect that's a distinct possibility, however. And this is another reference I found. This is particular to structural engineers, but it could be generalized to any professional engineering service provider. They should perform their engineering services with no less than the skill customarily exercised by other structural engineers in similar circumstances. So potentially someone can make the argument that the standard of care was met because all these firms conducted their inspections in more or less the same way. And the condition of this bridge was rated as poor going back to all the way to 2011. And it's possible it would have been rated as poor before that had an inspection been done after the initial rehab work in the late 90s up to 2011. Given the narrative in this filing, it appears that there was a 12 or 13-year gap of inspections. So another thing I'm surprised at is they're naming people in the lawsuit for things that were done clear back in 2011, and I don't understand how they can go back that far in time. You have a concept of statute of repose. Statute of repose is any law that bars claims after some actions by the defendant, even if the plaintiff has not yet been injured. Okay, then you have statute of limitations, is any law that bars claims after a certain period of time after an injury. So let's look at what I found for Rhode Island. For professional services, there's a 3-year limit for personal injury, professional malpractice, including medical, and product liability. Fraud and injury to property all carry a 10-year limit. So again, a lot of these services go back a long time. And I think the state of Rhode Island and their attorneys know they may be on shakier ground relative to the statute of limitations, because there was a bill introduced in Rhode Island to extend the limitation of liability to a period of 10 years. And from what I understand, that didn't pass. But the fact that they could even consider it after the fact is just unbelievable. I don't know why anybody would do business with a DOT or a state entity like that. Some other things that may help the defendants here in this case is Director of Rhode Island DOT, Peter Alviti, right after the emergency closure of this bridge back in December said, hey, the July 2023 inspection didn't show any problem. We were good. And now in December, the rod's broken. So there must have been some overloaded truck that went through unnoticed and did this extraordinary, or did this damage, and he called it an extraordinary event. So why is he spouting off? You know, he didn't even know the overall situation. So I think potentially there's been statements and actions made by Rhode Island government officials that may turn out to help potentially the defendants in these lawsuits. Now there's another dynamic here, and it could be a wild card. But the federal government has initiated a fraud investigation, and it coincides with the time period really for Peter Alvidi's entire tenure at Rhode Island DOT. I think it time period started a few weeks after he started. But here's a Golocal article saying the failure of the Washington Bridge is not the story of a broken pin or an inspector's report. According to those interviewed by Golocal, the breakdown of the Washington Bridge is a bigger story about the Rhode Island Department of Transportation under Director Peter Alvidi and the changes he has made in how contracts are awarded and much more. There's a change.org petition for Alvidi to resign. I don't think that's gotten much traction, but I know there's a lot of negative sentiment about how Alvidi has conducted himself in this whole episode. I think the state of Rhode Island may have made a tactical error by naming so many engineering firms in this lawsuit. Because again, from a broad view, it looks like everyone conducted their inspections in a similar manner. They had similar findings of poor condition for the bridge. And it's going to be really hard when you're going back over so many years to figure out when damage or problems with the bridge existed, or at what point did it develop later. And here's a photo. Apparently there's some blue paint overspray on the face of one of these broken anchor rods. There could have been the need to perform even more detailed forensics to establish the timeline of what happened and when, to include or exclude certain parties relative to this lawsuit. But I don't know that that's been done. And again, even the forensic report that was done by VN's got some problematic statements that I think may support the defendants in this case to some degree. Talk about limited inspection access. The geometry and detailing of the Washington Bridge does not allow for the complete assessment of post-tension systems. Okay, well, again, that could help the defendants. And ultimately, they recommended complete replacement of this bridge, and Rhode Island intended to have a contract for that. They only managed to award the demolition contract. They sent out requests for proposals for design and construction of the replacement bridge and got no one to respond, unsurprisingly, when they're apparently at that time looking to sue everybody who had been involved with the project in recent memory. So that's kind of a deeper dive on some of the business aspects and what's going on behind the scene. I'll be interested to see how this plays out. In some sense, I think it may be kind of a shakedown for some of these firms. Again, I don't know all the details. I don't know the ins and outs. There may be some legitimate causes for action in this lawsuit. But again, when you take it as a whole, and when you consider the fact that the government of Rhode Island has apparently zero interest in looking at their own contribution to these problems in terms of inadequate management, inadequate oversight, improper specifications, you name it, they're not interested in that. They're interested in getting money and providing political capital to the administration of the government of Rhode Island. That's my opinion. So there may be instances where the insurers for some of these engineering companies will settle their lawsuit just to get out of it, because lawsuits are very time consuming and expensive. So they may shake out a few million here, a few million there. I couldn't tell you, but that has been a tactic in some of these lawsuits. So I'll stay on the story. I want to send a shout out to the channel members. I really appreciate your ongoing support. I also want to send a shout out to those of you who provided super thanks. Check out the links in the description. I've got a couple of free digital downloads, one on the biggest civil engineering disasters of the past 100 years, and a summary of what's going on with the Artemis program. That's NASA's plan to get humans back to the surface of the moon. Thanks for watching, everyone.